awaits me from my winter hell. I've got candles and candy, I can be your daddy if you only let me creep into your prison cell. Hey baby, can you tell I'm not a criminal? Your choice is seminal. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. Just speak low, stand in your row, try not to show this life's a show. Try not to glow way down below. Oh, it's a lot of woe, and that's not a place where you would like to go. I've got cigarettes and brandy, which could come in handy if you just help me loosen up my hand grenades fuse. Baby, don't refuse my truth, but it's up to you not to choose. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true, 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 true.
Welcome back, you guys. How are you? I hope everybody made it over here safe and sound. I just wanted to say something really quick that I forgot to say on the last stream. J Rose, thank you. J Rose said that I was very pretty, and I appreciate that. Thank you very much. It's good to see you guys. All right. So I don't have, let me refresh once more and see what we get. I don't have anything beyond the 1209 report from Nate, which, by the way, Nate, can I just for a moment, let me just say something. Let me speak directly to Mr. Nate Eaton. Mr. Nate Eaton, I want to thank you. You have been a constant source for me, going through all of the pre-trials, everything, all the things respective to Lori Vallow Daybell Esquire, as well as her current husband, Chad Guy Thumb Daybell. You've remained a consummate professional through all of this, and you go above and beyond. Your updates from the courtroom have been invaluable. And I thank you for that. I thank you for covering all of this in the way that you have. I thank you for being a voice for justice for the victims, for Charles Vallow, for Tammy Daybell, for JJ Vallow, and for Tylee Ryan. Thank you. And Brandon Boudreaux. Thank you for that. And I hope we don't see each other. I hope we don't have anything else to talk about with Lori and Chad. I hope they fade away into obscurity. And I hope we do see you, though, when they charge the Melanies. So, Nate, thank you for being you. You're just fantastic, and I just can't thank you enough. I just adore you, Nate. Let me just say hi to you guys while we wait. We should be getting into the courtroom. Should be showing in just any minute now. Give me just 1 second. I need to respond to my daughter really quickly. Give me just one momentito. Okay. All right. So let me say good hi to everybody. Hi, Crocheting Bammy, Rachel Lee. Can we all take a moment to appreciate Rachel Lee's profile picture? You should come look. If you're busy, just take a brief moment, look away from whatever it is you're doing. Look over here at Rachel's profile picture. It's hilarious. Hey, J Rose, good to see you. Hey, Chicken Lady, good to see you. Dragon Lady, hello. Ooh, I like your profile picture too. Tess, what up? Crocheting Bammy, hello. Hold on, where am I? I got lost. Hold on, I'm lost. Oh, here I am. Okay. Hey, Sissy's mom, Jen, good to see you. Hey, Bogart, good to see you too. Welcome in. Sarah Bellum, good to see you. Kelly Renee, hello. I'm so glad you're here. Good to see everyone. Hey, Neat Noodle. No, don't go back now. I'll catch you guys up. I'll catch you up. Just a sec, Neat Noodle. Hey, Violet, good to see you. Julie A, welcome in. Good to see you. Hey, Fruit Fly, good to see ya. I think Brandy, hello. I think I got everybody. Hello, hello, hello. Sharon, good to see you. It's great for you to be here. I'm glad you got us live. Thank you, thank you, thank you. Let me see. Adrian, what up? How you doing? Good to see you. It's been a minute. Welcome in, welcome in, welcome in. All right, let me just hold on. I got to text her back. Okay. Give me just a second. I don't know what my phone is doing. It's not listening to me. It's not doing what I've asked it to do. So there we have it. Okay. All right. So basically what happened at the end of Karen Reed, the defense is going to rest. There shall be no rebuttal put on by the Commonwealth. The side chat and I think I can speak for them when we're all agreement in after the last witness and the deplorable, horrible way that freaking cross-examination went. Brennan, he doesn't want to put Dr. Welcher back on the stand. I don't blame him. Yes, Dragon Lady. So basically what's going to happen tomorrow, they're going to court starts tomorrow at 10 o'clock Eastern, 9 o'clock Central. Please don't make me do the math. 7 o'clock Mountain and 6 o'clock Pacific, I think is the right times. They're going to do the charging conference. That's when we're going to hear what the jury instructions are going to be. And I am anxiously awaiting those. Anxiously. Okay. Let's see. Yes. Okay. So we'll listen to that tomorrow. I think what's going to happen in Lori right now is Lori wants to hear Lori's going to say, hold on a second. Let me tell you. The defense is going to rest. Okay. So, just a minute. So basically what's going to happen is here we go. Is that right, Sarah? Because I know Arizona is mountain time and they don't do daylight savings time. And so when we spring forward in Texas Central Time, I'm 2 hours ahead of my family in Arizona. In the fall, I'm only an hour. Is that right? Yeah. Okay. Tomato, tomato. If you live there, you know what time everything is. And besides that, YouTube, as long as you change it, if you set your YouTube to your location, to your time zone, when I go live, whenever I schedule it, you guys will get notified and it will go live at your time zone and it'll even tell you what time that is. So, okay, here we go. Now, I'm Central now. I used to be Eastern Violet. So what's going to happen is Lori's going to do a Rule 20 motion. That's basically a motion for acquittal, a directed verdict, however you want to. They call it different things, but that's basically what it is. We're going to hear Lori's when testimony or when they resume from the courtroom. We're going to hear that. We're going to find out if Lori is going to rest. If Lori rests, then the judge will go right into jury instructions and we're going to, stop, they'll go into jury instructions. Then we're going to hear closing arguments. And then after the closing arguments are done, then the case gets turned over to the jury. It is entirely possible that the jury does it. It's possible because it's okay. So for Arizona time right now, it's 1:30. Okay. So I would imagine they let them go home the first day of deliberations. So they came back and deliberated the second day and then they came back the second day and had a verdict. So I think I think that might be what Medusa. I want one of these too. Okay, so Medusa said, I finally ordered an air fryer, supposed to get it today. Been saving my fries, tots, and nuggies for its arrival. I'm giddy with anticipation. I would be too. Let me say this. Okay. Thank you, Sarah. That's right. That's how it goes. I forget. I just remember the 2 hours. So for me personally, okay, when we moved to Texas, we stayed with our daughter and our son-in-law for a little while, right? You guys all know that I've never not made, and I've told you guys that. They have a countertop air fryer that they got from HEB. Okay. I cannot tell you. They have opened up. It's like a whole new world to me. Okay. The things that you can do with an air fryer. Now, the reason that I have an Instapot and it does all the things. It's an air fryer. It's a pressure cooker. It's a roaster. It's a dehydrator. It does everything. However, the way that I don't care for the air fryer implement, and it's not because it doesn't do a great job. It does a fantastic job. But if you're cooking for a family, like at the time I was a family of 4, okay, you cannot cook the servings for a family of 4 in that air fryer. You have to break it up, which to me seems pointless. Okay. So I know that Chicky Nuggy Pot Pie Esquire has an appointment to go back to the doctor's in Fort Worth in July. Granny will either be attending that doctor's visit or venoming the money because the air fryer that I want, you can only get at HEB. HEB is a Texas thing. It stands for here, everything's better. So, but they don't ship it to you. And so I have to go to the store. Okay. So, I really, really want to do that. That might be my, I don't know. I might not. Sometimes I don't know. Sometimes I feel guilty spending money like that. So, or spending money on things like that. So I might not. I don't know. I haven't decided yet. But regardless, that is a potential plan. I'm still waiting for them to be live. Okay. Apparently, the jury is supposed to return at 4:45 Eastern, which is 3:45 Central, and whatever that is Pacific, 2 hours later. So Arizona time would be 1:45. So, isn't it fruit fly? I love HEB. I love their produce. I love their tortillas. Oh my gosh. And I'm not talking about, oh, the tortilla. No, I'm talking about HEB tortillas. Hey, S. Hockett. Hey, Sprinkle Donut. Good to see you. So, yeah, I mean, I am, oh my God, Sprinkle Donut. Yes, they're amazing. What do you mean? You're doing life all wrong. Get you an air fryer, girl. You can have okay, you know what's good about it? The air fryer. This is what I like about the air fryer. You know how sometimes you want like restaurant fries, okay? But you don't want the unhealthiness in preparing them in the way that fast food prepares their fries, right? This gives you the fast food quality French fry without the unhealthy properties of it, okay? Without the grease, which I like, especially in the summertime because, when it gets hot like that, you don't want to heat up your kitchen. Oh my God, I sound like my mom. My mom used to say that all the time. It's too hot to heat. I don't want to heat up the kitchen. Um, so it's yes, I would highly, highly, highly recommend an air fryer. Um, I mean, yes, you absolutely can cook it in the regular oven, but here's the difference, in my opinion, crocheting Bammy. When you use an air fryer, if you get a good quality one that that can fit on your countertop, okay, um, it heats up right away. So it takes less time. So you don't have to go through the whole preheating of the oven and waiting for that. It's much more efficient and it's much quicker and it cooks in less time. So there is that. Um, oh my gosh. Sissy's mom, thank you. That's so sweet of you. Sissy's mom says, I know I say it all the time, but I'm so thankful for this community that you have created here. I love this family. Oh, Sissy. Thank you. Thank you, Jen. Is that the baby you're babysitting? Adorable. Adorable. I know, Sprinkled Donut. We all do become our moms at one point. It's true. It's true. But I also hear myself saying things that my dad says. Okay. Like as long as have grown up in the house with my dad, at no time did that man ever do dishes. I've never seen my dad wash a single dish. Have I seen my dad take a dish and put it in the sink? Sure. But actually doing dishes, no. I haven't even seen my dad turn on the water to soak a dish. Okay. But he did have thoughts on that. He used to get so mad when me and my sister, we would take turns doing the dishes at night, after dinner. And he would be like, you don't need to soak. How do you know we don't need to soak? You don't even do dishes, bro. You don't know. Okay. I don't appreciate that. I don't need that kind of negativity. But my dad had very fixed ideas about what a dishwasher is for. And my dad was insistent that a dishwasher is for sanitizing dishes. Yeah. Back when we moved into that house in Texas, even though at that time, it was a fairly, up to date dishwasher and it was new and all the things, right? It ain't nothing compared to what a dishwasher these days can do. Okay. And so I disagree there, but I have lived in rental homes where the dishwasher hasn't been so great, and I've had to tell my children who have loaded the dishwasher without rinsing first that the dishwasher, and these words have literally come out of my mouth. I don't know what y'all are doing. The dishwasher is for sanitizing. So now what we have is we're going to have sanitized stuck on food. Thanks. Oh, I would get so mad. I would get so irritated. And this is the other thing. How do you, as a child, right? How do you, as my kid, I very rarely had my kids load the dishwasher, but I never missed an opportunity to have them unload the dishwasher. Okay. Most of the time I would load the dishwasher. And here's why: because I started out having them do both, load and unload the dishwasher. How is it that you can look and watch your mom over all of these years load a dishwasher? You know how I loaded it because you're unloading it. And yet every single time you load the dishwasher, all four of them loaded it the most wrongity wrong way that you could ever load a dishwasher. Sissy's mom, when I first moved to Florida, I did not have a dishwasher either. I only hand washed. And Dawn Power Wash is the bee's knees. And even though I do have a dishwasher and have had a dishwasher for quite some time now, the last house we lived in Florida is the only house that we ever had a dishwasher in. All, the two other houses did not. The two other places did not. So I love Dawn Power Wash. And let me just tell you, Dawn Power Wash works on things that are not just like dishes. So you know how sometimes you will get like spillage in your oven or even like on the oven door. And I don't even know how stuff gets in between the glass on the oven door, but that happens. I can't do anything. I can't help tell you how to get anything off of that. But Dawn Power Wash works really great at getting stuff that's like dripped or spilt in the oven. It's good for cleaning the inside of the glass of the oven door. It is also very, very good at cleaning. I don't know what the technical term for these things are, but the burner, not the burners themselves, but those metal pieces that go in the burner catcher thingy, that thing. I know that those have a real name. I just don't know what they're called. Or I can't think of it right now. But anyway, if you put Dawn Power Wash on those, you spray it down really well and you let it soak and get unbubbly. Like, don't touch it. Just leave it alone. Gets it clean and just gets it so clean. Did you know? Okay, Kelly Renee. One time, yes, it's very different. It's a burner pan. Thank you, Violet. It's a spray. It's like a foam. It's so different and it's so much better. And I don't know what they put in that stuff, and I don't care. It's like a miracle worker. It gets everything out. Hey, Mally, good to see you. Did you know? So I was trying to get I wanted to know if you could clean in between the oven, the glass door part of the oven, the glass window thingy on the oven. Okay. I watched a YouTube video. Okay. And there is a YouTube video out there that tells you how to do it. But do you know if you take that apart to do it, that you void the warranty on your oven? Did you know that? I didn't. Oh, 13 ounces of water, 4 tablespoons of Dawn, and 2 tablespoons of alcohol is the recipe for Dawn Power Wash. Oh, well, who knew? I don't know. I just love that stuff. I love it. It's my favorite. We should be coming back any moment. Oh, Seems to be a little kerfuffle happening outside. If I was a nosy person, I'd put you guys on hold and go see, but I'm not a nosy person right this minute. Yes, I am. I am a nosy person. Hey, Wolfie, good to see you. Yes, it's the sprayer. It's not just like the recipe itself, okay? It's the sprayer. Kelly, I'm telling you right now, where is that? I just lost Kelly's thing. The Dawn Power Wash will get it off. Absolutely. See, my daughter let me use her baking sheet, and she only ever uses parchment paper on it. Well, I borrowed it when I made those ribs because I made a ton of them, and my baking sheet just would not accommodate all of the ribs. So I, lined it with parchment paper as well. But you know how that goes when you like especially with ribs, right? 'Cause they were marinated and then the barbecue sauce and whatnot. So inevitably a little bit of the stuff got on that baking sheet. So I sprayed it with Dawn Power Wash. Bruh. Let me just say this. It was clean. Like, yeah. Parchment paper, Wolfie, is, I'll show you. Hold on, let me show you. It's great for baking. Oh. Oh, crap, I pushed the wrong button. I always do that. Hold on. I'll show you. This is parchment paper. See? It comes in either the brown, which I use this kind. I use the brown color, but it comes in white, but it's perfect for cooking. It's the best stuff ever. This is parchment paper. I forgot to add it to the stream. It's not wax paper. Parchment paper and wax paper, I thought the same thing, but they're different things. Hold on. Let me just check that because parchment paper doesn't feel like wax paper. Let's make sure. Let's check the Google. Is parchment paper and wax paper the same thing? All right, here we go. No, parchment paper and wax paper are not the same, though they share some similarities. Parchment paper is heat resistant and typically coated with silicone, making it ideal for baking and lining pans. Wax paper, on the other hand, is moisture resistant but not heat resistant, making it suitable for wrapping and food storage, but not for use in the oven. There you go. Little baking tips from your girl. Where is... Hold on. Wait, what things? What are you talking about? I missed something. I wanted to show you because I thought maybe you didn't know. Not everybody knows about parchment paper. So there. I mean, I didn't know about all the 11 billion uses of parchment paper and when you should use it and what you should use it for and what difference it could make. Because let me just tell you something. I'm a new user of the parchment paper. Okay. I haven't always used parchment paper. In fact, I was a foil user. And I got to say, I prefer parchment paper. I only use foil now to cover food. Yeah. Yeah. And I'll tell you another thing. I really like Glad Press and Seal way, way, way more than Saran Wrap. Okay. And you know what? Yeah. First, outer, inner, last. That's right, Wolfie. Foil, like math. Aluminum. Aluminum. So, well, Tess is over here with her two different kinds of parchment paper. Look, Tess yesterday, while she was sending me stuff from the ex Twitters, was, she had made homemade pizza dough the day before, made pizzas, then used the leftover dough to make cinnamon rolls. She was doing all the things. So of course, Tess uses two different kinds of parchment paper. She's the Martha Stewart of the true crime community. Yeah. Yeah. Press and seal is better. It's way better. And you know what? I didn't get it the last time I was at the store and all I had was saran wrap. Yes, Wolfie, it's a good thing. I didn't have it. I didn't get it the last time I went to the store and I cut a watermelon in half because I made it for chicken nugget pot pie, but I didn't want to cut up a whole watermelon because I knew we weren't going to eat it all right then, right? And all I had was friggin' saran wrap, and I'm still disgruntled about it. Oh yes, Wolfie, get you some press and seal, girl. It's the best. You know when you like say you have. Okay, for me, I have like food containers, like from Ziploc, from Glad, but I also go back to the days when I was first a little homemaker, and sometimes you have to use like Cool Whip containers, the butter tubs, stuff like that. But sometimes you don't always have the lids that match those anymore. You know how that happens. And I'm not answering Woofy anymore. Woofy has used all of her questions for the day, so no more. I do not have all my lids. Sometimes they're missing. I have children. Okay, children lose lids to food storage. They lose socks, and for whatever reason, in this house anyway, they lose the small forks and the small spoons. Here we go. Lori's back. So let's hear what Lori has to say.
Charged in an indictment.
Daybell, Sierra 2022-001242. The parties are present. Ms. Daybell, go ahead.
With the Rule 20, Your Honor?
Yeah.
Okay. The court must enter a judgment of acquittal on any offense charged in an indictment if there is no substantial evidence to support a conviction. Conspiracy to commit first-degree murder requires the state prove that I, one, agreed with another, in this case Alex, that one or more of us would engage in conduct that equaled first-degree murder, and two, that I intended to promote or assist in the conduct. The only evidence that has been presented simply establishes that I have been seen on video placing items into a storage unit. A phone that is connected to me through an email made phone calls during this time frame, and a Google search relating to Gilbert, Arizona. None of this evidence establishes that I agreed with Alex Cox to engage in conduct that equals first degree. The state has the burden of establishing all elements of an offense have been committed, and thus there is not substantial evidence to support a conviction.
All right. Does the state want to respond for the record?
Sure. Looking at the evidence in the light most favorable to the state, there is substantial evidence for a jury to find the defendant guilty of conspiring with Alex Cox to commit first-degree murder of Brandon Boudreaux. In this case, in determining if a conspiracy existed, the jury can look at the fact that the defendant went with Alex Cox to buy the burner phone, that she loaned her Jeep to him to be used, that she rented a storage unit, that she Googled how to remove the rear seat, that she hid the tire and seat, and that she created an alibi for her brother by having those two phones interact while he was in Gilbert, Arizona.
All right. The standard is whether a reasonable juror could find the defendant guilty, whether there's substantial evidence that a reasonable juror could find the defendant guilty. The state has presented a compelling case that Alex Cox traveled to Gilbert, Arizona, and attempted to kill Mr. Boudreaux, there's other circumstantial evidence that establishes that the defendant was aware of Mr. Cox's plans and facilitated those plans and assisted in those plans in several different ways. It's ordered denying the motion for Rule 20. Anything else?
No, Your Honor.
All right, just confirming that the defendant doesn't intend on testifying or calling any witnesses?
Correct. I would like to again just admit the letter from Tammy. It
Oh,
was
did we-
marked.
Did we get
Just
it
wanted to
marked?
let you know that.
Okay, 203, for purposes of maintaining the record and any appeal issues, 203 would be admitted for the record, but not to the jury. Anything else? All right, let's bring the jurors in. I'll turn to the defendant when the jury's sat, and the defendant presumably will say that she rests as well. Thank you.
All right, so they're going to go and get the jury. All right. And then the judge is going to give some very, very brief jury instructions. And then the closing arguments. Lori, shut your mic off, man. Sheesh. And then the closing arguments will begin.
Be seated when you get to your seat. All right, thank you. The jury is now present. Everyone can be seated. The defense has rested before lunch. I'll now turn to the state rested before lunch. I'll now turn to the defense.
The defense also rests, Your Honor.
All right, at this time, we are going to hand out the final jury instructions. My assistant will hand those to the jurors. Do the parties already have their copies? Yes. Okay. All right, it looks like all jurors have copies of the final jury instructions. Much like the preliminary instructions, you're free to follow along or just listen. I'm going to read these instructions as required. It is your duty as a juror to decide this case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You as jurors are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Admission of evidence in court is governed by rules of law. I've applied those rules during the trial and resolved any issues concerning the admission of evidence. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that has been admitted. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. The state has charged the defendant with a crime. A charge is not evidence against the defendant. You must not think the defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. The defendant's decision to represent herself should not be considered by you when determining the facts. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and the defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial, or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of the charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce any evidence is left to the defendant. The defendant's decision not to produce evidence is not evidence of guilt. Before you may convict the defendant of the charged crime, you must find that the state has proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about October 2nd, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. The crime of conspiracy to commit first-degree murder requires proof, 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or other person knowingly One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises.
Lori's guilty. She did all of those things, jurors. Do the right thing.
Actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of the other participants until it is established that a conspiracy existed and that person was one of its members. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or new means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3.
These are pretty self-explanatory. I just want you guys to see this section right here. Lori, you went too heavy with the pollen lady. It looks bad. I mean, it didn't look good before, but yikes. Aren't you a professional?
Foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. Make sure every member of the jury is present during the discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict.
Hold on.
Therefore, the foreperson
What the
should...
frack? Wolfie, I can't remember who it was, but they spent time in the same jail that Lori did before she went to jail. And she said that the ladies in the jail be using the pollen denture cleaner to bleach their hairs. I'm just saying. I don't know if I don't know.
Verdict form as well.
I don't know about all that, but I mean, it doesn't look good. So I would say, yes, that's what's happened.
Return to the courtroom. The court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. In just a few minutes, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the written jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have any question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with the parties before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about the case until I accept your verdict. 12 of you must agree on a verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows. There is no significance to the order in which the options of guilty and not guilty are listed on the verdict form. At the back, this is the sample verdict form. You'll get an official verdict form from the clerk. But this is the sample verdict. Count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action, upon our oaths, do find the defendant, Lori Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about October 2nd, 2019, as follows. Check only one, and the options are not guilty or guilty. The state can proceed with its closing argument. Trey, need a mic up there? We're going to put a mic up on the podium.
Who would want to kill you? That is a question that Officer Mary Ann Robb asked Brandon when she first arrived. That's a question that Detective Pillar asked Brandon when he spoke with him. Brandon Boudreaux gave the exact same answer to both of these officers. He gave them 2 names. Lori Vallow, the woman seated over here, and Alexander Cox. He told them that he believed his shooting had something to do with an incident that occurred in Chandler in July of 2019, a couple months before this. He pointed them to that. He told them that Lori Vallow had lived in Texas and that the Jeep used in this shooting was from Texas. And then he told them what happened, how he had come home that morning. This Jeep was parked unusually close to his driveway, waiting. That he noticed there was no tire on the back. That he noticed that Texas license plate. That it was a 2-door Wrangler, and then he noticed that window go up. He saw the rifle come out. He saw what he believed was a silencer at the end, and then he heard and saw that bullet that hit the frame of his car, shattering the window right near his ear, causing that loud bang that he heard when that struck right near his head, mere inches away from him. Brandon drove off and called 911, actually panting in panic from what he had just experienced. This defendant's co-conspirator also drove off to try to escape, immediately calling this defendant's soon-to-be husband, Chad Daybell, and Googling a way to get back to Idaho Falls, sort of through back roads. The names that Brandon Boudreaux gave the police were correct, but Brandon had no idea of the amount of planning that had gone on leading up to this October 2nd shooting. As you've seen and heard in this trial, much of this conspiracy, this planning, this premeditation occurred in Idaho. So what I'd like to do is go through the evidence, discuss it all together in a timeline that might make a little more sense than the presentation during trial, and show you how it all fits together. Show you how all of this evidence points to one conclusion, that this defendant was involved in that conspiracy to commit first-degree murder. Next, I'd like to talk to you about the jury instructions, go through some of them specifically, and then talk to you how this evidence proves beyond a reasonable doubt that this defendant is guilty. And finally, I want to talk to you about, I'll call them so-called defenses. Maybe that there was no shooting at all, perhaps Melanie did it, or maybe just that this defendant wasn't involved. And we'll discuss those options. So let's start with a timeline that you heard from the beginning of this trial starts around June 25th, when Brandon Boudreaux learns that this defendant has been feeding lies to his then wife, Melanie. She has been telling Melanie things like Brandon hacked into her computer, that Brandon was gay, that Brandon was trying to take her temple recommend away. Brandon told you that he had heard these things from Charles too, this defendant's husband at the time, who had told Brandon that his wife, Lori Vallow, was telling Brandon's wife lies. What did we learn from this? Brandon, in fact, texted Lori about this, told her, why are you spreading these lies about me? Why are you destroying my marriage? And as you learned, she didn't respond. Then you heard about that July 11th, 2019 incident in Chandler, Arizona. The one that Brandon, both to Officer Rob and to Detective Pillar, said, this has to do with this incident. What you learned from Detective Duncan, who came here, was that on July 11th, there was an incident. Lori Vallow was there. It was at her house, and Alex Cox was there. In her garage was that 2018 Jeep Wrangler with the Texas plates LWD 0997. And you learned that Alex Cox has his own vehicle. He doesn't need to borrow his sister's. He can drive his truck anywhere he wants. As Brandon's divorce is progressing, and he's seeking a mediator and working through that, this defendant and her brother moved to Rexburg, Idaho. You were provided with various documents from search warrants, both through Detective Duncan and Lieutenant Hermosillo, through lolly time iCloud accounts for this defendant, showing that she had emailed Blue Skies, that she rented an apartment up there. We see that she was searching for areas up there. We also saw that her brother, Alex Cox, moved right up there with her. Now, you heard from Brandon that part of their divorce, Melanie moved into her own residence, and they put their community home up for sale. And on September 13th, when their home had sold, but it was still pending, he rented that house at 3875 East Phelps Street. He told just a handful of people that address. Melanie Boudreaux asked for it on September 17th, and he provided it to her. Why wouldn't he? The only other people who knew that address were his two neighbors and a couple of friends, 5 people. But the only one that knew this defendant and Alex Cox, the woman that she referred to as her mom, that was her mom figure, this defendant, Lori Vallow, is the only one that would have known that address so that Alex could go there later. We know that on September 25th, Brandon moved into that residence. And he moved in early because his then soon-to-be ex-wife was leaving out of town. We know in the same time period, Melanie knows the address. The plan is already starting. Alex is searching for places to shoot. He is also looking for tint shops. Not a tint shop for his Ford F-150, because if you lay in the back of the truck, of course all the neighbors can see you. He is going to borrow this defendant, his sister's Jeep, Melanie Boudreaux's mom. And so he finds a place that will tint that Jeep as dark as possible, so that even in the daylight, no one can see into the back, so he can lie in wait. We saw that not only does Alex search for and get to Dan's windows, and this is important. You may say, well, who cares? Of course we know that. We heard from Dan Moss. But when you start thinking about the other searches to these Gmail accounts and you want to authenticate them, you know that these are legit. Why? Because here's Alex searching how to get to Dan's, and then what does he do? He shows up there with this defendant's Jeep so that it can be tinted. What do we know? We know again from Dan that they spent $200. They're in Idaho. This Jeep is already tinted. Why would you ever put additional tint on that Jeep? It's not even your primary car. We see Lori Vallow driving her little Nissan Rogue all over the place because you need a vehicle that you can hide in the back of and that you can shoot out that back window from. The burner phone. We heard this morning from Nick Balance, and he talked to you about both the records that you have seen that were admitted, as well as now the Google location data and cell phone analysis. What do we know? That on September 25th, when that burner phone was purchased at that Walmart, Alex Cox's phone is there, and Lori Vallow's phone is using a cell tower in that area. They drive out of town to a different Walmart to go buy this phone. Lori Vallow doesn't live in Idaho Falls. She lives in Rexburg, but her phone is in Idaho Falls talking with Melanie Boudreaux. What do we know the next day? Alex Cox activates that burner phone. That burner phone is only going to be used for one trip. The trip to Gilbert, Arizona and back. This is what you learned from Nick Balance this morning. That again, Alex Cox's phone tied to that Google account is showing right there in the Walmart. This defendant's phone is also in Idaho Falls, utilizing a tower at that Walmart. Then we know on the 26th, when we're activating this phone, Melanie Boudreaux flies up here to be with the defendant. We know at this time, Brandon Boudreaux has the kids, and we know that they have an agreement. Brandon will keep them Monday and Tuesday and Wednesday. Wednesday, October 2nd, he will hand them back to her, and they will stay with her. So when he's shot and killed, it won't matter because she'll have the kids. It'll be fine. They know, because it's the plan, that their youngest gets dropped off every morning. Brandon will pull up to the park and let her know he's there. And so all of this information is known. Now, how do we know it's known? We know by the timing. And so we'll go through that. But remember, this is when Melanie's coming up and spending 3 days with this defendant. She has to be back Monday. Why? Because she's going to take the kids like she always does. Again, we have Alex Cox preparing for this shooting. We know he's not only practicing, but he's trying to figure out trajectory. What do we know? That this is a moving car. Alex Cox is going to have to try to fire out the back of a Jeep at a moving car. And ladies and gentlemen, he came pretty close to being successful at that. We know that Melanie flies back to Arizona. And then we have the beginning of the trip. And the beginning of this defendant starting the giant alibi defense that she does. Why would anyone ever take someone's cell phone and carry it around with them? Why would you take someone's cell phone and do that? Why would you make phone calls between each other other than to ensure that it looks like Alex Cox is still in Idaho? They think he has a burner phone. No one will even know. Great idea, other than we know he hooked it up to his Google account. So we know that the afternoon of the 30th, Alex takes his phone over to his sister's apartment. And it stays there or with this defendant until he returns on the 3rd. We know that at about 5:15, Lori Vallow searches how to remove the back seat of the Jeep. Alex Cox still is there, and now she is helping him get ready for his trip. She has his phone, she's giving him her Jeep, and she is helping him make it more comfortable so he can lie in wait in the back. They had to remove the tire, and they had to remove that back seat. We know that sometime that evening, Alex Cox leaves Idaho and moves towards Gilbert. We heard from Detective Pillar that there was an LPR reading for that Texas license plate LWD 0997 at around 8:10 outside of Rexburg, Idaho. We know from the balance that there is no phone activity until we see the phone arrive in Arizona. We also know that the Jeep is in Arizona. So we have the burner phone and the Jeep, and Alex Cox is Googling in Arizona. Holbrook, we see that LPR reader showing the Jeep with no tire on the back, so they can open that rear window, exactly as Brandon explained. This defendant's Jeep. What do we know is that, again, the burner phone is calling one person, this defendant's husband, Chad Daybell. We see that Alex Cox is in Arizona with other physical evidence. What is that? It's that receipt from Los Favoritos that was recovered inside the Jeep in Idaho. So we know the Jeep is down here. As much as the defendant wants to tell you about colors or whatever else, her Jeep was here in Mesa on October 1st of 2019. We can just stop pretending that didn't happen. We know as well, when we look at those Google records, we're trying to authenticate them, that the Los Favoritos was on Power Road in Mesa, and after having lunch, Alex Cox Googled another location on Power Road. Now, this defendant, in aiding this conspiracy and helping her brother, starts by renting that storage unit. Now, she rents that on October 1st. She also still is in possession of her brother's phone. So this way it looks like Alex Cox is going with her to the storage unit. She's providing that alibi because they don't think that the burner phone has hooked into this Google account. They don't know about the LPR readers. They don't think about the receipt. So Lori Vallow provides his alibi and she brings the phone with her, and we know that Alex Cox's phone is with this defendant as she's renting a storage unit. Even though we know from the video, he's not there, she's alone. When you watch these videos, and if you want to, they're obviously admitted, you will see one person get in and out of that car, and one person go into the storage unit. That one person is this defendant, Lori Vallow. So even though Alex Cox's phone is here, that's just a ruse. That's her aiding, that's her conspiring, that's her trying to cover up this murder for her brother, who is the shooter. What we know as well is by October 1st, we know the Jeep and Alex Cox are here in Arizona. And we know that that evening of October 1st, he Googles that address. The address that only 5 people knew. The address that this defendant's niece, the person she said she is like a mom for, that's where her ex-husband or soon-to-be ex-husband is living. He Googles 3875 East Phelps Street, even with the zip code into it. And then he gets directions there, getting prepared, knowing where he needs to go the next morning. Why? Because again, Melanie and Brandon have a very set schedule, and they know that Brandon's going to drop off the kids and then meet Melanie to pass off their youngest, and Alex will be waiting at home. We know the next morning, Alex Cox Googles again the address for Brandon's home. We know that that morning, Alex Cox's burner phone is utilizing towers near this defendant's niece, Brandon Boudreaux's soon-to-be ex-wife's home, Melanie Boudreaux. And we know that the calls that he is having are with this defendant's husband, Chad Daybell. And we know that by 7:22, Alex is moving towards Brandon's home. He knows that Brandon is going to be leaving to take the kids to school because Melanie knows the schedule, and he will be waiting when the kids are dropped off. The morning of October 2nd, Brandon has a very normal schedule. He's got to get his kids to school. He leaves around 7:25. He drops off his first kids at school, and then he meets with Melanie and drops off their youngest. Melanie does not know that Brandon is going to work out. Normally, he'd go home. Alex would be waiting there. But instead, he went to the gym. Now again, we've heard a lot of questioning of whether or not a Jeep existed there or not, but we all know that it's this defendant's Jeep. But we also know that a neighbor across the street saw the Jeep there, and not only saw it, but knew something was wrong. He told you that it was parked on the wrong side of the road, nose to nose with that white van, that it was running, that it had really dark tint. And in fact, he told you he was so thinking it was out of place that he actually looked in his rearview mirror to try to just see what the license plate was, and he noted it was a Texas license plate. He told you it was just a dark Jeep, whatever color that is. And we know at this time period again, this defendant's burner, or this defendant's co-conspirator's burner phone is still calling one person, and that is Chad Daybell, this defendant's husband. Now, we know that this defendant has been carrying around Alex Cox's phone, the phone subscribed to him, the one that if you looked at, you'd be like, oh, there's where Alex Cox is. Look at that Wi-Fi. She's been carrying it around, and now she knows if at 7:40 there's going to be a handoff of the kids, we need to make the alibi, 8 o'clock. And so at 8:02 Arizona time, she has Alex Cox's phone call her phone, and there's a fake 24-minute call. Look, Alex couldn't have done that. He's up here in Idaho with me. Of course, Brandon was at the gym, so it's a little early. But still, it's an alibi. Can't have run down to Arizona in those next 40 or so minutes. So we know, of course, that while that fake call is going on, the Idaho Falls burner phone is in Gilbert, utilizing cell towers that are in the area of 3875 East Phelps, and Lori Vallow's Jeep is parked right outside of Brandon's house, waiting for him to return home. We know that 20 minutes before Alex Cox shoots at Brandon, Lori Vallow's phone gets a call from Melanie Boudreaux. Here they are, still talking and conspiring, trying to figure out what's going on. Where is Brandon? Brandon returns home about 9:13. Alex Cox has been waiting there now for almost 2 hours. He returns home and sees that Jeep. Just like Robert Abitamarco, he notices it being parked really close to his driveway and it stands out to him. And of course, then he sees that window open and that barrel come out and this gun shoot at him and almost hit him. We know from Lynette Mendoza, who had a Ring camera, that just a few seconds before that shooting, her Ring camera had shown a black car, and you just see a bleep of it in the beginning as it kind of jumps, go by that corner. And then a few seconds later, you hear that loud bang. When you look at the time on that Ring camera that you have admitted, it matches up with that 911 call with when Brandon is calling in to say he's just been shot at. Like Brandon said, loud. You've heard a lot about the color of this Jeep. Even when we look at photos of the exact same Jeep here, they all look a little different. You have the DEA one that looks almost silver, or brown, I don't know. You have an upper one from Chandler that looks a different gray with a dark gray, and then you have the one from Dan Moss that looks more greeny colored. What do we all know? They all have the same license plate on them. They're all this defendant's Jeep. So when we're talking about color, that's just everyone's perspective. What do we know in actuality? That Brandon's Tesla was shot by a large round, that it hit.
Thank you, Wolfie. Credit for that photo goes to Wolfie, the one, the only, your friend and mine, Wolfie. Oh!
The corner of that glass that went up into the frame of his vehicle, that it left a divot in the glass, and that somehow the police, in trying to search a giant block radius, were not able to recover those pieces of the projectile. We only have a few fragments of it. But everyone who has worked these scenes knows that's a bullet hole, and those were projectile fragments, and that was a gun that Brandon saw, and that's a shot that he heard. Immediately after hitting Brandon, Alex Cox takes off and is searching for directions out of there. And you saw those, and you saw a map as he went east, and those matched with the cell phone and cell tower records that Nick Balance told you about. Brandon is on the phone with 911. Alex Cox is fleeing because he knows Brandon's alive. We know that the other part is that while this is going on, while Alex is searching for his way home and has been talking to Chad Daybell, knowing now that Brandon's alive, what do? They go hide the tire and hide the seat. So the timing of those videos when Chad Daybell, person who is talking to Alex Cox, and this defendant go to the storage unit is as Alex Cox is calling him and telling him whatever as he's fleeing to go home. So we know that they arrive there, and you can watch these. By they, I mean Chad Daybell and Lori Vallow. And we know that they bring in a tire and what looks like a seat. You can actually see Chad rolling the tire in. And again, why is this important? This is this defendant who has helped take the tire and seat out of her Jeep to make it available for her brother to take his guns down to Arizona to shoot at her niece's soon-to-be ex-husband. That's what we're talking about when we're talking about this conspiracy. As time goes on after the shooting, we know that, again, that burner phone and that Jeep are returning back to Idaho. In fact, Alex Googles all the way to Idaho Falls Airport. He knows how to get home from there. While he's doing that, again, we're having the storage unit. What do we know as the Jeep is coming back? It's back in Idaho and around Rexburg around the time of 3:54 and 4:28 when LPR readers note the Jeep back up there. What do both this defendant and Alex Cox do? They're both searching, trying to get the news. Brandon shot? Did he die? Did he live? What happened? Do they have leads? And again, when we talk about the Jeep and this idea that somehow it's not this defendant's Jeep, that she wasn't involved in this, we know that there was gunshot residue, characteristic particles that are unique to just gunshot residue located in the back of this Jeep, not on the seat or the floor, but on the windows. Why? Because when a gun is shot inside of a car, that dust goes everywhere. And that's why they were able to collect that. But do we know that even though this is the defendant's Jeep, Alex Cox's DNA is on it? So let's talk about the jury instructions. I want to go through a few of them in specifics and then talk to you about the charges. Burden of proof. The state has.
Yes, Wolfie. Yes. Yes. I don't care. I'll howl again. Oh, I'd rather be a howler than a lot of other
Proof
things.
beyond a reasonable doubt. And you're told that proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. That there are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. When we talk about reasonable doubt and that burden of proof, I want to start with what it isn't. Proof beyond a reasonable doubt is not proof beyond all doubt. It's not proof beyond all possible doubt. It's proof beyond any reasonable doubt. And I'll give an example. When Kyle Mueller was on the stand and he was questioned about gunshot residue, he was asked, for instance, if a bunch of hairspray could cause the GSR in the car. And he said, well, maybe like one of the particles, but not all three. So maybe if all they had found, possibly, you could say that was a doubt, but is it a reasonable doubt that hairspray caused the GSR in the car? No. So let's talk about direct and circumstantial evidence. And that's because we have a mixture of both here. So direct evidence is evidence that a witness saw, heard, or otherwise sensed an event. What Brandon told you about that happened that day. What Robert Aboutamarku told you about. That's direct evidence. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. And you're told the law makes no difference between direct and circumstantial evidence. So I'm going to give you an example here as well so that we can understand what you can do with circumstantial evidence and why it is so important. Assume you are seated on a beach, and it's in a cove, and you can see on each side, you lose sight of people. While you're sitting there, you're the only person on the beach, there's no footsteps there, and you see a person come from your left, walk in front of you and go to your right. They go around a corner, you lose sight of them. A couple minutes later, someone comes in and says, hey, did you see anyone come by? And you say, yeah, they just went that way. That is direct evidence. You saw it. Now imagine you're on that same beach, same situation. Sand is smooth, you close your eyes for 5 minutes. When you open them, you see footsteps now on the beach. You can see the toes and the heel. So you can see the direction as it crossed again from your left to your right, but you don't see a person at all there. You know your eyes have been closed for about 5 minutes. Someone comes up and says, hey, has anyone gone by? And you go, yeah, I mean, in the last 5 minutes, someone went that way. That is called circumstantial evidence, and you are able to infer from that that someone went by. So let's talk about the crime. The conspiracy to commit first-degree murder requires that the defendant on or about October 2nd, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct that constituted first-degree murder. I'm going to go through a few things, then I'm going to talk about them all together, because these jury instructions really have to be considered as one. So conspiracy. When we're talking about conspiracy, we're talking about the defendant agreeing with Alex Cox and others to engage in that conduct, first-degree murder. That she had to intend to promote or assist, and that's going to be very important here in the commission of that conduct. She doesn't have to be the shooter, she has to promote or assist it. And that the intended conduct would constitute the crime of first-degree murder. Again, doesn't have to be completed. That's why it's conspiracy to commit first-degree murder. Proof of the membership. You're told that one may become a member of a conspiracy without knowing every detail. She doesn't have to know how long Alex is waiting there, what type of bullets he's going to use. The evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or other persons participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. In determining whether a conspiracy exists, you should consider the actions and statements of all of the alleged participants. So you're going to have to look at everything and look at what this defendant did to promote or assist that conspiracy. So, first-degree murder. Again, I'm going to just note that conspiracy means the parties agreed to engage in that conduct, so it doesn't mean there has to be a death. They are conspiring to kill someone. So, we know that someone shot at Brandon Boudreaux and came very close to causing his death. They have to intend or knew that he or she would cause the death of another person, which when you are shooting at them with a rifle, that is what you are intending or knowing. And they acted with premeditation. Talk about premeditation and then we'll wrap it all together to discuss. So premeditation means that they intended to kill another person and that they formed an intent or knowledge and then reflected on it. Now, in Arizona, premeditation does not require some long, drawn-out plan. Reflection can be very fast. But in this case, we have premeditation that is days and weeks before this. We're talking about September 23rd, 24th, 25th, all the way through up to October 2nd. So this premeditation is above and beyond what is required by the law. This defendant started helping when they went to buy that burner phone. When she loaned her Jeep to allow it to be tinted. When she Googled how to remove that rear seat and they took off the tire and she kept it with her. Then she rented a storage unit and put it in there. When she kept her brother's cell phone and kept it with her as she went around Idaho. And when she made that call between those two phones, right around the time of when the shooting was supposed to occur. That is the aiding and the promoting done by this defendant. That is her acts. That is the conspiracy. But again, you look at all of the evidence to see how does that fit in. It's not just someone holding someone's phone. If that were it, sure, we might wonder what's going on. But you can't look at these facts simple and separate. You have to look at the actions of everyone and see how that fits in with all the evidence in this case. This defendant didn't just go buy a phone at Walmart and that was that. This defendant didn't just rent a storage unit and put her own personal property in there. This defendant didn't just decide to loan her Jeep to her brother and then decide to take the rear tire off it and the interior seat out of it. She did all of these things to aid and promote this first-degree murder. When we're talking about defenses in this case, there are potential ones we'll talk about. You've heard in this trial that maybe there was no shooting. There's not even a first-degree murder because I believe there were some thoughts about that the hole in his car was made by a tire iron or whatever other defenses there were. But what do we know? Yes, there's a shooting here. Brandon's car has a bullet hole in it. There are fragments from that bullet hole in there. There's damage to his glass consistent with that location of the bullet hole in his car. Brandon called 911 out of breath from the fear of having just been shot when that bullet hit the frame of his car right near his head and shattered that window next to him. The Ring camera and that gunshot that you heard. Robert Abitamarco putting the Jeep there is idling there. So, is that a defense? No. There was a shooting. So what else? We've heard something about Melanie doing it. She had a financial motive. And I'm not here to tell you that Melanie wasn't involved in this. I'm telling you that this defendant was also involved in this. When we talk about a conspiracy to commit murder, there can be multiple people involved in that conspiracy. There were multiple people involved in that conspiracy. Melanie Boudreaux is the only one that had the address. So, yes, she was involved. But was she it? No. This defendant helped ensure that her brother could help Melanie by killing off her soon-to-be ex-husband, by loaning him the Jeep, by helping make the Jeep available and accessible to fire out of, removing that rear tire, removing the seat, allowing him to put the dark tint on it, and taking it with him. And then providing that alibi over those days while he was gone to help cover up that he was the shooter. I think she also said maybe she's not responsible for what her brother has done. But we know she is responsible. She is a co-conspirator. She is assisting, she is promoting in this crime. We know from the 25th on, she is helping to get the phone, to get ready, to make the Jeep ready, to cover up for her brother, to hide those extra parts. to Google how to even get the Jeep ready, and eventually also trying to figure out what went wrong so they could then determine what to do after. Brandon Boudreaux knew who was involved. He may not have seen who did this. The defendant has tried to explain away the evidence and questioning witnesses, asking if it's possible for a single piece of evidence to mean something other than what everyone knows it means. Is it possible that a Coke bottle broke in the street and one little shard stayed there right where Brandon Boudreaux's Tesla was located when it was shot? A shard that looks just like the glass from his car in the driveway, inside the seats. Is it possible that a tire iron made that bullet hole in the Tesla? Is it possible that the GSR in the Jeep is hairspray and fireworks? Is it possible that a Jeep with Texas plates belonged to someone else who wanted to kill Brandon? Is it possible that Alex was in Idaho and called her on October 2nd at 8:02 for those 24 minutes? Don't fall for the defendant's questions about what is possible when the evidence shows exactly what occurred. The only explanation when we look at all of the evidence together is that this defendant conspired with her brother and others to try to kill Brandon Boudreaux. The state asks you to look at all of the evidence, not just the is it possibles, and find the defendant guilty of conspiracy to commit first-degree murder. Thank you.
All right, the defense can give its closing argument.
Well done, Trina. Tied it up, wrapped it neatly, and tied it with a nice bow for the jury. Fantastic job. Also, Melanie's, girl, you going down.
When a family breaks apart, it is a tragedy, with the devastation far-reaching, affecting.
Oh, Jesus, fuck. Are you seriously going to go with this? Because it worked so great for you last time.
Many people. I am not exempt from tragedy, none of us are. But what we learn from it is most important. Because of this experience, I've studied the law and the judicial system, and that knowledge will stay with me forever. When we experience tragedy, we can grow stronger from the experiences, and then those experiences are not all negative. You would think that often people in my position would feel defensive or angry. And from where I'm standing, I understand that very well. But I don't feel any of those things. You have watched me under pressure, under scrutiny, and even under attack. And I have shown you that I'm not on any of those things.
I'm going to object to character evidence and testimony that's not in
Sustained.
evidence.
Ms. Daybell, could I have you pull that microphone a little closer, please?
You can't be upset with people who are forced to look at your life from a distance or judge it through a lens that's being intentionally distorted or being at least very limited. Like the lens the state has shown you on this event. There's so much more going on that is not included to your view. The law prevents some of these things from being shared
I'm
in
going to
trial.
object, Your Honor, to improper.
Sustained.
You have seen opinions formed by strangers trying to put together a narrative. I have shown you that basically there is no defense to what a person did not do or did not participate in. Other than what you've seen, which is no evidence that I made an agreement to commit a crime, because no such evidence exists. So I'm not defensive. I'm not angry. Nobody has all the pieces to this puzzle. It is complex. Like most families, this is a complex issue. And like the state, I was not there. But there is no agreement, no plan, no gain. I am no stranger to tragedy. The breaking up of a family is tragedy. On June 25th, 2019, Brandon Boudreaux decided that I was responsible for his family tragedy. And I'm really sorry that he feels that way.
No, Your Honor, I'm going to object again to testimony.
All right, the jury is reminded that what is said in closing statements or closing arguments is not evidence, it is not testimony. The intent of the closing argument is for each side to argue what the evidence shows.
I would like to submit that this is what Trina Kay really wants to say to Lori.
No, you shut up! Don't talk to me! Don't talk to me, criminal!
All right, let's keep listening to this ridiculousness.
Go ahead.
I did and have supported my niece Melanie when she suffered tragedy as a young child and during this terribly difficult time in 2019. We read the text from Brandon to me on June 25th, 2019, where he claims that he will never stop until he proves that I am responsible. Well, here we are, almost 6 years later, and I'm charged with conspiracy to commit first-degree murder. In order to have a conspiracy, 2 or more people have to make an agreement to commit a crime. There is no such agreement between me and my brother Alex, although I did love my brother Alex.
And I'm going to object again, Your Honor, to testifying.
Sustained.
There is no agreement that was shown to you between myself and Melanie Boudreaux, although I love Melanie.
And I'm going to object again to testifying.
Sustained.
I cannot tell you what happened that day on October 2nd, 2019, because I was not there.
And I'm going to again object to testifying, and please strike everything the defendant has said.
All right. The defendant is admonished, you cannot argue things that were not admitted into evidence.
The prosecutor wasn't there. Law enforcement wasn't there. Only Brandon knows what happened before he called 911. Only Brandon said he will not stop. The fact that I supported Melanie in her time of need does not make me against Brandon. I had nothing to gain by Brandon being hurt. Brandon has worked with law enforcement for almost 6 years to make sure that I pay a consequence.
I'm going to object to misstating the evidence.
Sustained. The jury will determine what the evidence did and did not show.
Your job is to determine if I committed a crime, this crime, a conspiracy, an agreement, not cleaning out a garage, but an agreement to commit murder. You did not see an agreement. You did not hear an agreement. You heard Detective Duncan say that he had spent hundreds of hours going over my iCloud accounts. They have 19 years of my accounts, text messages,
And I'm going to object to
calls.
misstates the evidence and no.
If there was an agreement.
Hold on. The objection sustained. The jury is reminded that they will determine what the evidence did and did not show. Go ahead.
If there was an agreement, they would have showed it to you. There is no agreement. We've all experienced tragedies in our lives, and naturally people want someone to blame, someone to pay a price. My brother is no longer here. We can't ask him about that day. There were things presented in this case that I did not know.
And I'm going to object again to testifying, Your Honor, and ask to strike.
Sustained.
Things that I saw, I thought,
And again, I'm going to already ask to strike.
All right. The defendant cannot testify to things that were not testified to from the witness stand.
Yeah. Shut up, Lori. Thank you, B. Frank, who says, help a girl out. What should I watch at this train wreck? Just stay right here where you're at, B. Frank. Just watch this with us. That's it. That's all, babe. That's all you got to watch. This is all the dumpster fire train wreck you will ever need to know. It's going to be wrapped up all very shortly for you.
Because this is the theory the prosecutor wants you to see, it is limited. How can we say clearly when the law only allows for a skewed view of things? The devastation this family has gone through is the tragedy. After almost 6 years, it's time for healing. Thank you.
State wish to give a rebuttal, close.
Thank you.
All right, the state has the burden to prove the defendant guilty, and since they have that burden, they have the right to open and close the argument. Go ahead.
Never, Wolfie. She didn't get the death penalty.
The defendant wants you to think that Brandon has it out for her. She has tried to insinuate that Brandon was involved with working with Detective Pillar for years just to get her. But what you heard was that Brandon has actually been working with law enforcement on multiple investigations, and that in fact Melanie Boudreaux is a subject of multiple investigations. So again, as the defendant sits up here and tries to portray and paint a picture for you of her innocence and sadness and family tragedy, she again misrepresents what was told to you at trial. She tells you there was no plan, but she ignores the facts and the evidence of a very obvious long plan. A plan that started when she began, this defendant, Lori Vallow, meddling in Melanie and Brandon's marriage. And when that marriage was finally ending, this defendant continued to help her niece, Melanie. She continued to aid her. And what we see in every one of these bits of evidence is a core group of people. This defendant, her brother Alex, Melanie Boudreaux, and Chad Daybell. The four of them working together. Do we need to have words, a video? No, we do not. That is why there is that jury instruction on direct and circumstantial evidence, because you look at what is going on here, and it screams to you a conspiracy by this defendant, by Melanie Boudreaux, by Alex Cox, and by Chad Daybell to kill Brandon Boudreaux. Every action you see there, the defendant would like you to look at them individually and pretend that they don't all point to what happened on October 2nd. But everything they did leading up to then shows you a way to cover up and prepare for the murder of Brandon Boudreaux. When we talk about a plan and this defendant's actions, the most obvious and screaming piece of information is this defendant holding on to her brother's phone for days, holding on to the 480-351-9120 number for days while her brother is gone, with her Jeep, without the rear tire, without the back seat, with a gun with him. That is part of the plan. That is the assisting, that is the promoting, that is the conspiracy that this defendant wants you to pretend doesn't exist. We don't need words. We have actions that are obvious, and they're done by this defendant and her co-conspirators. The state asks you to look at everything together, regardless of how many people want to cry up here, regardless of how many people want to try to testify. This is not evidence. What is evidence is what was presented to you in trial, and each piece of that tells you this defendant is guilty. And so I ask you to find her guilty of the conspiracy to commit murder against Brandon Boudreaux. Thank you.
All right, members of the jury, the case is going to be submitted to you shortly, but first, we're going to draw our alternate jurors. Again, we have extra jurors just in case someone becomes sick or is unable to proceed. So we're going to call 3 alternate jurors. If you are an alternate juror, it may be disappointing to get to this stage in the trial and not be in the deliberation process, but I have in the past had to call back an alternate juror to come back in the jury room when a juror is unable to proceed. So the admonition would still apply to you until we call you and let you know that you're excused. If I don't see you again as far as an alternate, I won't.
You know what? Be frank, this is a good question. Why didn't they try them all together? I'll tell you why. I'll tell you what I think. Okay, so we know that Zulema got immunity, all right? But I think that Arizona waited and let the events and the trials for both Lori and Chad play out in Idaho to see what they would say on the stand. And I think that it's coming. It's coming. I think that's why.
I want to thank you for participating in this process. We couldn't have done it without you. Now we're going to use our very scientific method and draw numbers out of a hat here. Juror 3, you're our first alternate. We're going to draw another.
16.
16, okay, and
7.
jurors 3, 7, and 16, 7, okay. I'll come back and talk to you in a few moments before you go, but please, the admonition still applies. I have had to call alternates back. Again, I thank you for your service in this matter. We're going to swear in my staff, the staff that I have so far. My Jay is on vacation this week, so go ahead.
Do you swear that you will take charge of this jury and protect their deliberations from all outside interference and communication, and when they have reached a verdict, you will bring them back into court without revealing their verdict to anyone, so help you God? I do.
All right. The jury is excused at this time to begin their deliberations.
All right, you guys, we are officially on verdict watch. Wolfie, with your permission, may I please use that picture as my thumbnail? Please, 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 for verdict watch. I think this is everything. We have one more thing to happen. All right, so they got to deliberate, they got to return a verdict of guilty, and then there is a sentencing hearing.
All right, please be seated. The jury is no longer present.
Oh, hold on. Let's see if there's any ridiculousness to come from the demon over here.
I'm going to put everyone on notice that it would be the court's intent to take a verdict within about 20 to 25 minutes of being notified that the jury has a verdict. So if you want to be present for that verdict, I would advise everyone to stay within about 20 minutes of the courthouse. In other words, in the immediate downtown area. The state has filed an allegation of aggravating circumstances back in January of 2024.
Right now it's 317 in Arizona.
One of those aggravators is essentially kind of an overlap with the finding of dangerousness. What other aggravators would the state intend on proceeding with if there were a guilty verdict?
Your Honor, we could just prove the dangerous allegation and accomplice. That would be sufficient.
Okay.
Are you going to, again, ask some dumbass
Last time we
questions?
discussed this issue, the
Lori?
defendant was requesting a probable cause hearing, but also indicated that she didn't want to have an aggravating factors hearing. So let me ask the defendant, last time you admitted aggravators. I don't know what your intent is on this time around.
I would object to aggravating. Of course, I would object to it. I asked for a 13.5 hearing on it so that those aggravators could have probable cause.
Oh
If
my
you're going to go
God.
forward with them, then I will stipulate to them.
All right. Well, the court, I don't think you're entitled to a probable cause hearing, but based on the evidence that was admitted, the court would find that there's probable cause been established that this was a dangerous offense and that there was the presence of an accomplice.
B. Frank, oh, so sweet of you to tip me. Thank you so much. How long will they go? Let's bet 3 hours. I bet tomorrow morning. I bet tomorrow morning only because, oh, you want the total time. Okay, so yeah, that's about right. I'll go 3.5. 3.5 hours.
I'll go ahead and prepare the instructions just in case, and then we'll see what the jury does. Please make sure that my assistant has the necessary contact information for everyone. But again, I would ask people to stay within 20 minutes of the courthouse. All right, thank you.
All right, so according to Colby, the jury went home. So, yeah, I guess 3.5 hours. Oh, did he? Oh, he was able to be there. Oh, wow, Tess, that's cool. When they do it in Arizona, they usually. This is what they did last trial. The jury deliberated for all of, I think, 37 minutes or something like that, and then they sent them home. So that, because it's, the thinking, I think, is that they've been there all day. Let them go home. Let them get something to eat. Let them go get a good night's sleep and begin deliberating in the morning. So, all right, you guys, that's all I got for you tonight. I'm pretty beat. I don't know if I'm going to make it to Donna Adelson tonight. If I don't make it to Donna Adelson tonight, don't go watch it nowhere else, because only I can roast Donna in the way that she deserves to be roasted. Just kidding. You can watch it wherever you want, but just make sure you watch it. Come back here too. I don't know when I'll do it. Well, actually, I do. I probably will do it tomorrow night, because we're about to they're starting late tomorrow with Karen. The jury's deliberating in Lori, so I'll just do it tomorrow night. How about that? All right, you guys. Thank you so much, everyone, for being here. Thank you to the mods. I appreciate it so very much. If you wouldn't mind, one last thing, give your girl a thumbs up on the stream. I'd appreciate that too. You guys have a great rest of your evening, and I will see you all tomorrow with the charging portion of the jury instructions over in Karen Reed. All right, you guys have a great time. I will be here tomorrow. Court begins at 10 a.m. Eastern, so I will be here at 8:55 Central, 9:55 Eastern. All right. You guys have a great day, rest of your night, and I'll see y'all later. Thanks for spending time with me. All right. Bye, you guys. Have a great night. Talk to y'all later. Bye.